gratuity payable to him be paid a pension equal to...
This is Wadu TV, truth and integrity. This is Wadu TV, truth and integrity.
And upon retirement under the clause, he shall not hold any private office of profit or emolument, whether directly or indirectly.
Honorable nominee, may I know from you whether, in view of the provisions in Article 126, having regard to your earlier position that to enable the court function properly, human resource is critical. That is, judges and officers of staff, judicial service staff must be paid well. Would you recommend a constitutional amendment which will incorporate the lower court justices, i.e. district magistrates, circuit court judges, to come under this provision of retiring on their salaries? Would you recommend that?
Mr. Chairman, this depends on the kitty. I wouldn't recommend that. I think this is an incentive for you to work hard and enter the superior court. I think it's a way of rewarding you for your hard work. So I wouldn't recommend that everybody falls into that category, sir.
Now, Superior Court justices come under Article 71 office holders, correct?
Yes, Mr. Chairman.
So, High Court judges, Court of Appeal judges, and Supreme Court judges, every 4 years, enjoy the Article 71 emolument, correct? Every 4 years, correct?
When you say emolument, every 4 years they enjoy the emolument, I don't understand you. Judges, our salaries are not reviewed every year. It's done once in 4 years. So what is paid back is the difference. That is what is paid every 4 years.
Let's go to Article 71. Lord, let's go to Article 71. Yeah, my Lord, if you may read 71 for us.
Okay. All of 71.
Rightly so.
The determination of certain emoluments, 71. The salaries and allowances payable and the facilities and privileges available to A, Speaker and Deputy Speakers and Members of Parliament. B, the Chief Justice and the other Justices of the Superior Court of Judicature. 3, C, the Auditor General, the Chairman of the and Deputy Commissioner of the EC, the Commissioner for Human Rights and Administrative Justice, and his deputies, and the District Assembly's Common Fund Administrator. D, the chairman, vice chairman, and other members of D1, National Council for Higher Education, so described. 2, the Public Service Commission. 3, National Media Commission. 4, Lands Commission. 5, National Commission for Civic Education. Being expenditure charged on the consolidated fund shall be determined by the President on the recommendations of a committee of not more than 5 persons appointed by the President, acting in accordance with the advice of the Council of State. 2, the salaries and allowances payable and the facilities available to the President, the Vice President, the Chairman, and other members of the Council of State, Ministers of State, Deputy Ministers, being expenditure charged on the consolidated fund, shall be determined by Parliament on the recommendations of the committee referred to in Clause 1 of this article. For the purposes of this article, and except as otherwise provided in this Constitution, salaries includes allowances, facilities, and privileges, and retiring benefits or awards. Thank you.
So, back to your earlier position, you said that every 4 years, when this committee meets and makes recommendation, because your salaries are not done yearly, they make recommendations and you are paid salary arrears, correct?
Yes, Mr. Chairman.
Which is known on the streets as emolument.
Yes, Mr. Chairman.
So, you disagree with any suggestion to the effect that Article 71 is only there to benefit the political class from the reading you have just made? From what you have just
Mr.
read.
Chairman, what the Constitution says is what it is, not the interpretation people put on it. This is not, it doesn't mention a political class here. It mentioned the categories of people who should enjoy this Article 71 emoluments.
Yes. So I'm saying that from what you have just read, those to benefit from Article 71 is not limited to the elected political class. That's the point I want to make from what you've just read.
Yes, I think you are right.
Correct. Now, my Lord, I want us to go back to an earlier position taken by my respected learned colleague, the leader of the House, Honorable Ayarga. He relied heavily on the CJ, Justice Araba Isaba Tokono's recommendation to suggest to you that there's really nothing wrong in increasing the numbers at the Supreme Court. And you seem to have agreed with him, correct?
But the reasons given by the honorable man, I said yes.
Very well.
Because I haven't seen the article she wrote.
Very well. Yes, of course, he quoted from the, copiously from the letter. Now, you would agree with me that this proposal led to a public outcry. But now, we are adding 7 more to the same court. Would you, as a beneficiary of this, would you say that that criticism was unfounded?
Mr. Chairman, if I got it right, it's the Judicial Council that raised the first criticism. the Judicial Council, if I got it right, that the names didn't originate from them. That is all I know. So it was not like I am a beneficiary of, like the word you use, beneficiary. No. I was nominated by the President of the Republic to become a Supreme Court judge. I don't know whether it's based on an article or anything. I just was nominated, Mr. Chairman. So I cannot tell whether I'm a beneficiary or people, no.
My Lord, the argument was to the effect that the courts, the Supreme Court, the highest court of the land was being packed. And in fact, a colleague of yours who had been vetted, I think my lady, is it Benasco, wasn't it? Yes, I have here. Your colleague, Justice Sophia Rosetta Oduokua Benasco Esa, who had been nominated, vetted, and a report submitted to the plenary. As a result of this rather loud disagreement, Parliament could not even take the report. And the loud disagreement, including threats on the floor, the laying of the report would generate chaos, eventually prevented the laying of the report. I want to know from you that in view of the argument that even these two adding to the Supreme Court would amount to packing, would you now disagree with that opinion that this 7 being added, of which you are a beneficiary, worsens the matter?
Well, before allowing the chairman of the committee to answer the question, I would ask that the issue of a threat to the laying of the report be expunged from the question. Please proceed to give an answer.
Chairman, I speak of the record, though I will respect your ruling, but I will pull the Hansard. Fortunately, my respected colleague who used the word, there will be chaos. Hansard captured him. If you are ruling it out now, I don't mind to take that one out, but I will bring the Hansard to just, we are not done yet, so I would bring it, so at least once there's a record.
Honourable members, I believe and support the principle that matters that happen on the floor of Parliament is a closed book. Please proceed to give your answer.
Thank you, Mr. Chairman. I'm not even privy to all that happened in Parliament, whether there was chaos or there were threats. I don't know anything about that. I have just been nominated to the Supreme Court. I don't know anything as to whether I benefited from anything or, I don't know, Mr. Chairman. I can't exactly tell what happened on the floor of Parliament. That is what I can say, Mr. Chairman.
My honorable nominee, did you become aware of the general apprehension in the public space regarding the two nominees as same amounting to the packing of the Supreme Court? Did you become aware of the general apprehension in the public domain at the time?
No, Mr. Chairman.
Okay, fine. Would you disagree with any suggestion to the effect that these 7 nominations from the president at a go amount to the packing of the Supreme Court? Would you disagree with that suggestion?
I think you answered this question, said no. So why is the question being repeated? So, Honorable Minority Leader, with all due respect, proceed with another question. He says no to it.
Honorable nominee, the Supreme Court of Ghana has not been capped by any constitutional imperative, correct?
Yes, sir. There's no cap.
You would therefore agree that circumstances may result in having a certain number on the bench, correct?
Yes, sir.
So, in view of that, you would disagree to any suggestion that seeks to condemn or criticize or create a certain apprehension when nominations are being made with justifications for the number to go up to a certain point. You would disagree?
Mr. Chairman, it depends on the justification. It depends on the exigency and the justification accorded to the nominations. Thank you.
You will agree with me that the current 7 nominations have not been accompanied with any verifiable justification or exigencies. You would agree with me?
Mr. Chairman, I'm not the appointing authority. So I wouldn't know why. So it's difficult for me to answer why.
Man, I want to register a protest on record. I know that you are not sharing your power. I would plead through you to my respected colleague seated immediately to your right. The interjections, though not on record, those interjections are becoming too loud and too many. And we've started well. The man seated there, I've appeared before him, and he knows me very well, and I know him very well. We are discharging a constitutional duty. If it were to be on personal level, I say, my Lord Jamefe, please, I've passed you. We are doing a constitutional exercise, and we have political views on certain matters. You've had your turn. This thing that we do, then it get out of hand, the public misconstrue us. I don't want it to happen. Please restrain him. Please restrain him. It must not continue.
All other members are accordingly restrained. The floor is given to the minority leader and the ranking member of the committee. So
you must add or sign him to be say that.
No, this attempt to run me under the bus, I won't accept it. Were you not interjecting me? Were you not? Did anybody protest?
You have the floor. You have the floor. Please continue with your question.
Honorable nominee, may we do some exercise on constitutional evolution and textual fidelity? In your view, when should the Supreme Court adapt constitutional interpretation to changing circumstances, whereas at the same time, a view regarding adhering strictly to original text has to be complied with? And maybe let me hear you on that, then I can do a follow-up.
Mr. Chairman, the Supreme Court, as the apex court, is a policy court which we cannot deny. That is why they are not bound by their own decisions. When they think fit to do so, they can depart from their decisions based on the evolving nature of the law and situations. So the Supreme Court, saying that something has to be done, are at liberty to depart from their previous decisions. That's why they are not bound, Mr. Chairman.
Can you provide an instance where you would favor evolution and one where you would insist on textual fidelity? I know I have a textualist right by me, but who am I to even say he's seated to my left or right? I have
Please
a textualist with me.
proceed to ask your question. Nobody seated by you has the power to interpret the Constitution. Ask your question.
So may you provide an instance where you will favor evolution and an instance where you would insist on textual fidelity?
Mr. Chairman, if the Supreme Court gives a decision, we are all bound by it. But then, when you can depart when the decision is given per incuriam, or a wrong law has been applied, or the decision becomes unjust in the circumstances. And if you can differentiate the facts, you can depart from it, Mr. Chairman.
Honorable nominee, let's talk about judicial ethics and independence. Would you be able to give us 3 specific measures you would implement or you suggest to be implemented to maintain judicial ethics whilst preserving independence?
By the ethics of our job as judges, 1, you go strictly by what is before you, that is the evidence before you, and the facts. If I got the question right, you base your decisions on the evidence and the facts before you. You are not to depart from this. And then if it's I don't know whether it's the social aspect you are asking, your comportment, your rapport with lawyers who appear before you, it's there. You must know how you relate to parties who appear before you, the language you use in court, comportment, as I said earlier, your punctuality, even your own outlook as judges. And then you must not meddle into politics. You must be independent. You must just give out your mind. You don't care whether it's coming from A or B. These are some of the ethics we go by. And then you must know where you go and where you don't go, where you are seen and where you are not seen. Thank you.
So in view of that, how would you then balance the question of transparency with the need to avoid inappropriate commentary on legal issues.
You just have to know how to balance it. It's a thin line. If you heard me earlier, I said comments and opinions passed by judges carry a lot of weight because you don't know when a case will come before you. So you have to be very sparing as to comments you pass because, one, a case may come before you and the facts may be different, not on all fours. You have to depart from what you said. Even some people can even petition your recusal from the case because of a comment you once passed. So you have to be very careful as to the comments you pass as a judge because it carries weight.
Now, you are aware of the ECOWAS court. You've become aware of the ECOWAS court, my lord.
Yes, Mr. Chairman.
And you've equally become aware of other judge-made laws in other jurisdictions that sometimes lawyers appearing before you may rely on for persuasive purposes, etc.
Yes, Mr. Chairman.
Now, in your view, should foreign constitutional precedents influence Ghana's constitutional interpretation?
Mr.
And
Chairman,
if I may add,
sorry.
If I may add, just to make it composite, when, if ever, should the Supreme Court cite decisions from, say, South Africa, United States, United Kingdom, or even ECOWAS court decisions? I may take it again if you want to take down the question. Are you okay? Okay, proceed.
Mr. Chairman, any decision from outside is persuasive. It's not binding on us. But then, for sake of best practices, we are not a committee of nation. We belong to a committee of nations, sorry. We are not an island. You can learn best practices from other areas and import into the law, but that should not override your own laws, because whatever comes from outside is persuasive. Mr. Chairman.
Now, on the issue of democratic theory and constitutional purpose, I want to know from you, do constitutional term limits serve primarily to prevent individual power concentration or to ensure democratic competition, in your view?
Mr. Chairman, I don't understand
I'll repeat.
the question. Yeah.
I'm saying that I'm now delving into area of democratic theory and constitutional purpose. And my question is, in your view, does constitutional term limits serve primarily to prevent individual power concentration, or it is there as a constitutional imperative to ensure democratic competition?
Can you give me some examples, please?
Yes. The example is that, for instance, in Ghana, there is a constitutional term limit that, okay, for the presidency, your term, 4 years, you can go again. And you earlier answered it when you said somebody was trying to, my colleague John Daku was suggesting to you that, does that mean consecutive terms? And you said, the Constitution says 2 terms, and that's it. Of course, we've had Professor Kwesi Prempeh, the chair of the Constitutional Review Committee, being very clear that 2 terms means 2 terms. Now, with that background in mind, what I'm asking you to share a view on is whether or not this provision is there to primarily prevent individual power concentration, or is there to ensure democratic competition? Is it clear now?
It's clear. Mr. Chairman, what the Constitution says is the law. Whatever you say beyond the Constitution is noise. And no matter the many noises you make, the law is what? It's the law. You can't read any meaning into it apart from what the law says, Mr. Chairman. It says 2 terms. And whenever the Constitution gives a term limit, you have to follow it, Mr. Chairman. Unless it's amended or repealed, you don't have a choice. There's no other interpretation you can give to it than what it is, Mr. Chairman.
My Lord, you have earlier expressed a view on interpretation methodology. And you ran us through the various issues to consider. And I think I heard Honorable Ayariga commending the view expressed and invited the students to pay attention to that. Having given that view, and I would want to ask you this. Ghana, which sometimes can have politically sensitive cases, should the Supreme Court err towards restricting or expanding executive power when text permits multiple interpretations? And if so, what factors will guide that?
Mr. Chairman, I've said this several times with all respect, that what the Constitution says is what should be done. I don't know what more to add, sir. If the Constitution says 2 terms, I don't see how a different interpretation can be put to it. Mr. Chairman, I don't know what, that's what I think, sir.
My Lord, your colleagues who came before you, especially during Kufuor's era, had cause to give a certain interpretation to the Constitution. And just for our purpose, I remember that in looking at the law, they suggested, they made a strong point in their judgment to the fact that once the president is out of the jurisdiction, there must be someone in the jurisdiction to act. And the person must take the judicial oath. Now, it's been long. This ruling or judgment has been in our books for so long a time. It's like what we previously, as lawyers, were adhering to, that when an injunction application is filed, though it has not been determined, once you've been served, you must not do anything to disturb it. And we're going on with this for a long time, till recently in the Coasifua 3-2 decision, my Lord Kulendi, writing the majority opinion, said no, there must be express order from the courts. That is now the new law without any ambiguity on the practice. And you've talked about AI this morning, on repeated occasions. In view of technological impact, having regard to Article 68, would there be a requirement for the Speaker to take presidential oath when acting in the absence of the President and the Vice President?
Mr. Chairman, if the law says he needs to take an oath, he has to take it. If it doesn't say so, then he doesn't take it. Thank you.
But does the law say so? The Constitution says so, that he must take an oath when acting as president. take the presidential oath. Does the Constitution say so?
Yes.
Lord may guide us with the particular exact provision, please.
If you see, I think it's article. Well, I can't get it offhand, but Mr. Chairman.
We can look at it. You can take your time and provide that later. But you can furnish us with that later. But my Lord, my question directly related to this is that in an era of instant global communication, does this distinction remain constitutionally necessary? And should, quote, absence from the Republic, unquote, be redefined, in your view?
Mr. Chairman, with technology now, absence, it has a different meaning now, because a case came before me as to the meaning of working from home, as to whether during the COVID time, working from home, whether it's from your house or from outside the workplace. I think if the president, this is my opinion, please, if the president should be out of the country, let's say for 1 day, and coming back, yes, the Constitution says there should be no vacuum. But if the president has, if the technology can make you work from outside your office, but well, the law says if you are out of the jurisdiction, fine. But if you are in contact with those who you work with, I don't really think, and the period is that short, maybe 1 day, I don't think there should be this ceremony when you are coming back the following day for somebody to swear an oath. And then the following morning, the president or whoever's oath is taken is back.
Is my law departing from the law is the law?
The law is the law, but I'm not departing from it. But what I'm saying, this is my personal position. Mr. Chairman, what I'm saying is that, let's say the president goes to Nigeria and will come back in the evening. He's not in the country, but that does not necessarily mean that the vice should take an oath to act for him when he's coming back in the evening. I mean,
so, my Lord, Lord, so you yourself, you are very dynamic in your views, because you see, earlier, your view of the law, when we were talking about some other provisions, you were like, the law is a law, which is true. But again, you have now qualified it, giving it a purposive interpretation to meet the times by saying that, yes, if the person is going out for just 24 hours, would there be the need to have that ceremony of having to take the oath and all? So, therefore, you would agree with me that eliminating the speaker's oath requirement in such circumstance would be prudent, correct?
no, Mr. Chairman, what I said was my opinion. That was my opinion. May
Oh,
not
you are here
necessar-
to express an
yes,
opinion.
may
I
not
agree with-
necessarily be the law. If the law insists that,
My Lord, is your opinion that becomes a law. The Supreme Court is policy decisions.
it doesn't override the Constitution, sir.
Well, my Lord, we would reserve that debate for another word. But
All right, thank you.
I will come back to you. Let the
you.
chairman intervene, and we'll go back to it.
Honourable members will listen to my Lord very well. He indicated that the law is a law. The thought-provoking issue that he is stating is that if the president is traveled to Nigeria and will come back the same day or the following day, both the president and the vice president are not there, do we have to do the ceremony by way of swearing in the speaker, only for him to return after the swearing in to come and take his position? So these are issues that we can look at. So he still believes that the law is the law.
So, well, Lord, I think the jury is out there to have their own bite, so I will not belabor. Now, there is clarity to me on the issue of, in the absence of the president, the vice president acts. There is also clarity to me on the issue of, in the absence of the vice president, the speaker acts. But what is not clear to me is the earlier position regarding, the earlier position you took regarding the Chief Justice, that in the absence of the Speaker, the Chief Justice would have to act and take the presidential oath. Now, my Lord, is this position you took earlier in response to a colleague's question emanating from the Constitution expressly, that in the absence of the Speaker, the Chief Justice takes the oath of office as acting president? Is there such express constitutional provision? Or you are just, you stating so as a matter of course, that there should be no power vacuum? Because obviously, like it happened recently, it may happen again, where the president was out, my Excellency, Madam Vice President was on sick leave, and then Mr. Speaker was also out on official assignment, and for 48 hours, there was no head of state, technically, in the jurisdiction.
Mr. Chairman, I was answering a question asked by an honorable member as to the hierarchy. If the law says that for somebody to act as the president of the country, he must take an oath, that person has to take the oath.
My Lord, take it easy.
No, I'm fine.
No,
I'm
no,
fine.
you step by step.
I'm fine.
Let's, I mean, it's a good exercise that we have to embark on. If there is a lacuna in the Constitution, we must recognize it as a nation, and I believe the Constitutional Review Committee is following proceedings here. Now, my first question, and I will take it step by step. Is there an express constitutional provision that require the Chief Justice to take the presidential oath in the absence of the President, the Vice President, and the Speaker of Parliament? Is there an express constitutional provision?
Mr. Chairman, on top of my mind, I can't give any now. But if I'm given the chance, maybe I'll go through and see whether the Oaths Act or, I don't know, says so, or I don't know.
So let's do a little exercise. Granted, there is no such express provision. In your view, as a judge, and my Lord, it is your opinion that will add up to other views once you get to the bench. That court is a constitutional court. And if I may recall, I once did a case at the Supreme Court where, after losing the case, one of the panel members passed a comment that here we take policy decisions and look at the broader, affairs of the state. Just to assure me that don't be too heartbroken that you've lost this case. And it was a very sensitive matter that had to do with some. So that is the background to the point I'm making. Now let's come back to the issue. In the event that the Constitution does not make an express provision for the Chief Justice to act in the absence of the Speaker, the Vice President, the President, who, in your opinion, should act as President?
You
Honourable
mean
members,
if the vice is not in?
Let me take it back.
Yes.
The president is not in the country. The vice is not in. The speaker who took the presidential oath has also traveled. Who is the next to take?
Mr. Chairman,
Is there an express provision?
you see, there shouldn't be a lacuna. At every point in time, somebody must head this nation. The three are not in the country. The next person is the Chief Justice. The next person, as we all know, is the Chief Justice. Even if there's no express provision stating that, there shouldn't be a lacuna, there should be a vacuum. And what I was saying, Mr. Chairman, is that if the president is just away, or those who are just away, or one of the three is just away for within a day, he will go and come back, there is no need for that exercise. Because the person is coming back the same day. I don't know. Mr. Chairman, I think...
My Lord, if you look at Article 60, if we run through Article 60, all through to 12, my Lord, I do not see any express provision. I've read, I'm still a student. My reading can never be accurate. I've read 60, the entire 60. There is no express provision for the Chief Justice to act in the absence of the Speaker. And my Lord, I am laboring on this point because recently it happened where Mr. President was out, VIP was not in town, Speaker himself was also out of town on official duties. And, so I just want to know from you, you are now going to the bench, what is your view? I hope there's clarity now. Thank you very much.
It's clear. I think there's a lacuna there. So it has to be filled up. There shouldn't be that vacuum. So I think the Supreme Court that has the power to interpret can come out to say that, to make it definite that when those three people are not there, this person takes over. And this is
Which
what...
person? This person? Mr. Speaker, my Lord, this person.
When the president is not there, the vice takes over.
Yes.
When the vice is not there, is the speaker. And if the speaker is not there, I think there should be some express provision to say that there shouldn't be a vacuum.
So tell me your opinion. In your view,
my opinion,
who should be the
my
next?
opinion, the next should be the Chief Justice.
Very well.
That is my personal opinion.
I agree. No, my Lord, it's fair. Yeah. It's the personal opinions that become the law to guide us. I agree. Thank you very much. My Lord, I want us to deal with emergency powers, emergency succession protocols. Now, constitutional succession framework designed for unprecedented circumstances. In your view, should temporary successors beyond the vice president have full executive powers? And what constitutional limitations, in your view, should apply? Because they've taken an oath. They've taken the presidential oath.
Yeah, Mr. Chairman, yes, they've taken the presidential oath, but I don't think they can exercise all powers in the absence of the president. There must be a limit. For example, if the president should travel, the vice travels, and then the speaker takes an oath to act, and he decides to change ministers, appoint new ministers in the absence, it's not the best. So I think, yes, to avoid a vacuum, yes, somebody must lead, but certain decisions cannot be taken by that person. I think so.
But the person has taken a presidential oath.
Yes.
Now, how would you balance governmental continuity with democratic accountability in extended succession scenarios.
I don't understand, please.
So we've talked about succession. They could be temporal, but we can have situations where the time could prolong. And in your view this afternoon, you have also said that, look, those powers must have limitations. For instance, the person acting should not have the power to fire or even appoint ministers. I've heard you. Now, I'm saying that in view of that, how do you balance this governmental continuity, which is allowing somebody to act, and the requirement of accountability?
Mr. Chairman, the state must run in the absence of those people, as we said earlier. Yes, we have to balance it. The state must not come to a standstill. But then you must know the kind of decisions to take in the absence of the substantive people. That's what I think, sir. The state must run.
My Lord. In your view, what are the specific constitutional amendments you recommend to modernize Ghana's political succession framework?
Can you please clarify the question for me?
Well, I'm rooting it on the earlier foundation that I laid, the temporal succession, who is taking over and all that, in the absence of this, that, and you've already expressed some broader views. Okay, so I now would want to hear your views regarding some recommendations, because you've talked about some limitations. I just need you, in view of that, to make certain proposed recommendations by way of constitutional review. Because you agree with me that even the inclusion of the Chief Justice in the succession plan is now coming by way of a purposive approach to governance, that you don't have to leave it vacant, vacuum. There shouldn't be vacuum, but there's no express provision. So share with us what you see as some recommendations to guide this whole process, because it's very critical in view of the experience we've just had.
Mr. Chairman, I think this is for Parliament to do. You have to pass laws as to what should be done in those circumstances. I beg, sir.
My Lord, so you mean we should enact a law to regulate Article 60 further, but we can't enact where
or further, maybe when that issue comes before the Supreme Court, through the interpretation, the decision they will give, then they will clarify and give further instructions as to what should be done in those circumstances.
My Lord, you remember Article 1815, the Clomega? The Supreme Court left that bit to Parliament, and it is still hanging, where they said Parliament should enact to regulate 1815. It's in the light of this that I want to ask you whether in such circumstances, in view of the amendment we're looking at, Supreme Court in taking this up would look at it holistically and provide a guide without saying Parliament should so do this bit, because this is very constitutional, in my view. What do you think?
The duty of the Supreme Court, when it comes to interpretation, is the Supreme Court. So these are very good points you are raising. I think the Supreme Court, when the matter comes before them, will have to sort it out and give the various guidelines as to what should be done in the circumstances, Mr. Chairman. I think it's a gray area. So when it gets to the Supreme Court, then they will define it and give further guidelines as to what should be done. Thank you, sir.
My Lord, the records have it that you've been at the Court of Appeal since 2010, correct? Or more? Since 2010.
2010.
Okay. And you presided over that committee, that football committee. What's the name of that committee? There was a commission of inquiry or committee.
Mr. Chairman, you
has been implemented to guide football administration in our country.
Mr. Chairman, some were, but not all. We recommended a lot of recommendations, but not all were taken. But I can give some that we did, and we said, one, players should not be paid cash. We all saw what happened in Brazil when we had to fly money to Brazil for players, and we saw some people holding theirs. It was one bad thing for Ghana. Then number two, we also recommended that the state should not sponsor supporters to go to countries, to fly them to countries where we are playing. Instead,
That one is still happening.
well, I have done my job. Because we were thinking that instead of flying people from Ghana and booking hotels and feeding them, why don't we buy tickets for Ghanaians who are in that country? Then again, we also recommended that every time the Black Star plays, at least 3 local players should be in the team for continuity, 3 local players. And you all saw the House of Oak goalkeeper, the local player who did very well in the post, conceding no goals. These are some of the recommendations we made. And then that we also recommended that the state, the Parliament should know all matches to be played in the year ahead of time. I think sometimes the organizers wait when it's a week or 2 days to the match, then they bring their budget and you are forced. The only event in the world you cannot change is FIFA events. If FIFA fixes a match, you can never change it. You are forced to find money. So we recommended that matches should be, the state should know far ahead of time so that they can prepare towards those matches, not to wait till 2 days and then they bring you a budget. You have to, by all means, find money and send the players. These are some of the recommendations we made.
My Lord, this is a good point to ask my very last question to end the day.
Thank you very much.
To end the day with you. My Lord, you dealt with criminal cases for many years at the High Court. It came to a point in our criminal jurisprudence where lawyers and judges came to a certain conclusion that there was this non-bailable offenses. Until the same Supreme Court now came with a groundbreaking or a landmark decision that bail cannot be used as punishment. And certain parameters were created. Now, that is court's bail. To conclude the day, is inquiry bail at the administrative level, where a state institution investigating a person and is unable to complete investigations and is not for court, would grant bail on certain terms. Now, for all your years as in the public space, I just want to give my Lord enough background to it. I mean, ordinarily I'll go straight, but because the exercise is very good for
rules, that when you are given the opportunity to ask questions, our rules does not allow you to address. The rules does not allow you to share your opinion or argue. That is why I am just reminding you that you are to ask questions.
Okay, Chairman, that's okay. Thank you. I'm guided. So, Honorable Nominee, I am giving you this background in view of the fact that in recent times, Iyoko specifically, they have justified their action of requiring landed property titled, registered with the Lands Commission with valuation report as the basis for their bail condition because of the amount they are investigating. Because of the amount they are investigating. As a judge, don't you think that these considerations are matters for the court to determine? And that to the extent that the investigative body, like Iyoko, is not done with its investigation to bring the person to court, demanding landed property as a condition for bail merely because there is an investigation to that amount would be a bit onerous.
Mr. Chairman, from my experience, when we are faced with granting bail, we look at the charge, the amount involved, if it's liquidated, if it's money, the amount involved, and weigh the pros and cons as to whether the person will consider not coming to court for trial, whether the person is a flight risk, and we consider all that. You can't be, the basis of bail is to make sure that the person comes to face trial. But then, you can't be investigating a case, let's say, for example, $1 million in a theft case or something, and grant bail 10,000 cedis. There's a possibility that you are indirectly telling the person, go away. So we consider all these things. But I cannot tell what informed that decision by Iyoko. No, I cannot tell. I cannot tell. It's not yet at the court level. So I can't tell why they demanded that. I cannot fault them for that, sir.
My Lord, I'm not saying fault them. Yeah, my Lord, I'm not saying fault them. My Lord, I'm not saying fault them. On the issue of courts, I have no problem. Because you, the presiding judge, will now look at the charge sheets, the evidence available, and in fact, in our modern criminal trial system, you even make available all your documents you are relying on as part of the discoveries, contrary to the previous practice where you keep it and be releasing them one by one. Now, from day one, you have to give every document to your adversary or to the accused concerned about the use of such powers at the investigation level, where you have not even concluded, but you know that the amount you are investigating is X. It could be right or wrong. It could be true or wrong you to do. We are expressing a view to enrich democracy.
Mr. Chairman, at the investigative level, they are not saying you are guilty or not guilty. Granting bail and putting a figure on it is just to make sure you are available. And Mr. Chairman, don't forget that when you get to court, there's the possibility of the court varying even your bail bond, lower or even higher. So it's just a means of making sure that you attend, so you report yourself for the investigation. That's all. That's all about it, sir.
Yeah, thank you very much, my lord. We have come to an end of the vetting. Permit me to recognize our revered justices of the Supreme Court seated behind you. Then I will come to the family members. First on the list is His Lordship, Justice Paul Bafoboni, Acting Chief Justice. You are welcome. His Lordship, Justice Isifu Imoro Tanko Amadu, Justice of the Supreme Court. His Lordship, Justice Henry Anthony Kofi, Justice of the Supreme Court and President of Association of Magistrates and Judges of Ghana. His Lordship, Justice Richard Ajay Frimpong, Justice of the Supreme Court of Ghana. May I, on behalf of the committee, welcome my lords in our midst. I then proceed to acknowledge the presence of Mrs. Antoinette Jamape, the wife of the nominee, Mr. William Krakani, Dr. Kofi Dako Anoche, Togbi Honuape, Chief Honupe, Chief of Lume, Togbi Haji Sulfada Lume, Togbi Apana Jamape Lume, Togbi Romachi Lume, Mr. Mauli Jamape, Mr. Dan Jide, Dr. Mauli Ajore Adjoe, Director General TVET Ghana. We also have Commodore Retired Julius Jamape, Akofa Wallace, Mr. Derek Tetefio, Mr. Benji Halm, Chairman, Premier Keep Fit Club, Tema. Mr. Do, Patron, Premier Keep Fit Club, Tema. Mr. Ken Thompson, former MD, Dalex Finance. Mr. Eyome Aka, Mrs. Mawena Aka, Mr. Bonnie Lawe exposed to you. You are hereby discharged. You will surely hear from the committee. Thank you very much for coming.
Thank you, Mr. Chairman and honorable members.
Honorable members and our guests, it's time for lunch. You are invited to join us, take lunch together. We are resuming exactly at 3 o'clock to take the next nominee. Thank you very much.
This is Wadu TV, truth and integrity. This is Wadu TV, truth and integrity.